Over 300 judicial officers have been appointed to adjudicate election cases as members of the Election Petitions Tribunal for the upcoming general elections. The Chief Justice of the Federation, Justice Olukayode Ariwoolo, urged them to be fair and adopt strict professional ethics in the discharge of their duties. Ariwoolo, who stated this at a workshop held in Abuja, urged judges to take their duties as a call of national service and give it their best.
This is not an undertaking to be handled with levity. It is a solemn pledge between your lordships and your creator. For being privileged to be found worthy to serve in these tribunals, your lordships are expected to conduct your affairs within the ambit of the law and the oath that you have just been administered on you. Anything short of that will place you on a collision course with history, and then God will ask you the questions that you might not be confident enough to answer. I won't stand before you to reel out long speeches or homily, because as judicial officers and civil servants that are amongst you, this is certainly not the first time you are taking an oath. So, you must have had different admonitions on how to be upright and always live above reproach. I can confidently tell you that this is a weighty undertaking you have just signed before the Almighty God. I am saying this because, as the Chief Justice of Nigeria, I will not condone any act of recklessness, abuse of power, and public trust.
I hope that you will each uphold the trust reposed in you and in discharge of your duties at the tribunals. Your lordships must not allow yourselves to be used as conduit pipes for evil machinations. You must stand up to your values and good conscience at all times. Your decisions must be based on your clear understanding of the facts and the law and application of the law that you swore to uphold upon your appointment. You are being reminded of that oath today by being sworn in once more by the Honorable Chief Justice of Nigeria for this specific assignment. By the nature of your office, all sorts of avarice will come your way. That is the nature of your assignment as judges of the tribunal, election tribunal. But you must be in total control of your courts and refuse to be used as tools to truncate the process. It is imperative to state that this painstaking exercise is not a pet project of the Court of Appeal. The magnitude of this program is eminent in the interest and support we have received from our partners, some of whom are the United States Agency for International Development, USAID, UKAID, the UNDP, the European Union, Policy and Advocacy Center, PLAG, DIA, IFES, and indeed INEC itself. It is not being sensational to say that these days are very trying times for the judiciary, and the spotlight already on our institution will most certainly be intensified by your performances and your pronouncements. Let me once again reiterate that you must resist all and any form of pressure and influence, as well as gratification that may come your way. You are to discharge your duties strictly and in accordance with ethics and dictates of good conscience and the oath of office. Frivolous and unnecessary applications for adjournments particularly are to be shunned, and such applications, where necessary, must be considered strictly.
This workshop could not have come at a better time. It is exactly 109 days to the 2023 general election, holding in two phases: the national election, meaning presidential and national assembly, that is Senate and House of Representatives, holding on the 25th of February 2023, and state elections, governorship and state assembly, holding on the 11th of March 2023. Elections will be held for 1,491 constituencies, made up of 1 presidential constituency, 28 governorship elections. In 8 states, the elections are now held off-season, like the last we conducted in June and July in Ekiti and Osun. 109 senatorial districts, 360 federal constituencies, and 993 state constituencies. Most significantly, it is the first general election since the repeal of the 2010 Electoral Act as amended and its reenactment at the Electoral Act 2022. Over the next 4 days, 10 papers will be presented and discussed by eminent jurists, lawyers, and election experts. There will also be an interactive experience sharing session on pertinent issues in the determination of election disputes, presided over by the Honorable President of the Court of Appeal. I have no doubt that this workshop will enhance the understanding of INEC processes, especially the innovations introduced pursuant to the enactment of the Electoral Act 2022, which came into force on 25th February 2022. The new Electoral Act contains 80 new provisions intended to improve our elections and address some of the lacuna in the repealed Electoral Act 2010 as amended, provide legal backing to the technological innovations introduced by the Commission over time, and the extension of timelines for the nomination of candidates and for other electoral activities. Similarly, the new Electoral Act confers exclusive jurisdiction to hear pre-election cases on the Federal High Court with regard to candidate nomination in order to reduce forum shopping by litigants, abuse of court process, and reduction in the spate of conflicting judgments by courts of coordinate jurisdiction. We are reassured by the inspiring speech by my Lord, the President of the Court of Appeal, for the elaborate steps taken against conflicting judgments by courts of coordinate jurisdiction.